Welcome to Commercial Real Estate Now, live from Key West and the Stark and Stark Best Practices event. I'm your host, Karly.iacono, and I'm joined by Dee Kelly, the partner and group lead for the real estate department at Stark and Stark. Dee, how are you today?
Great. Thanks, Karly. It's great to be here with you.
Wonderful to be here for another fantastic Best Practices event. And the sun came out in Key West, so we're happy to have another great day ahead.
Yes.
We're going to be talking today about something very important to investors, and that is understanding clauses that you really need to be careful when negotiating on real estate acquisitions. And this is both from the buyer and the seller perspective, right? Because really good deals are made on the forend, right? It's made when you are looking at all these clauses, and negotiating contract provisions correctly is a huge indicator or factor in risk during your hold period. So we want to talk about things that cause conflict in contract negotiations and how quality representation can help work through those. So why don't we start before we get into this riveting, very important topic? Just give me a quick background on you and Stark and Stark.
Sure. Thanks, Karly. I am the chair of the commercial real estate group at Stark and Stark. We are a law firm. We're based in New Jersey, but we handle transactions nationwide. And we do purchases, sales, leasing. From soup to nuts, we handle your real estate needs on the legal side.
And you're fantastic to work with. I can personally vouch for you. That
Thank you.
Outstanding transaction.
You're also lovely to work with and fantastic. So
now that we got all of that, out of the way. So moving into, it's a tough topic, right? What are the clauses that cause the most friction in contract negotiations? Because from my side as a broker, we just want the contract to get signed, right? We're about efficiency, moving the deal forward. And I understand that it takes time to work through these provisions, but what are the specific sections or areas where you see the most holdups and the most challenges between buyers and sellers?
Sure. So when we get the contract, all of the business terms have been negotiated at that point. Typically, a letter of intent has been signed. And so now we're focused on managing the legal risks going forward with the transaction. And if you're representing the buyer, managing their risk during their hold period and minimizing the risk when you represent the seller for anything post-closing. So in light of that, when I get the contract or when I'm drafting the contract, usually the sticking points are related to the risk management in the representations and warranties. And there oftentimes are different perspectives on each side as to who should bear the most risk with respect to particular issues. So we see that play out a lot in the representations and warranties provisions.
And from my side, it's usually sellers want no reps and warranties, and buyers want indefinite reps and warranties on every topic because everyone, like you said, is trying to mitigate their own risk. So finding that place where both sides are comfortable is really
and finding it quickly because
right.
As you mentioned, everyone just wants to get the deal done and they don't want to be held up with negotiating legal terms.
Right.
So working towards getting to that resolution as quickly as possible while also managing the risk is incredibly important.
It's the key. Talk to me about indemnification language. Like how does that tie in and what does that look like?
Sure. So oftentimes in a contract, there will be indemnification language. From a seller's perspective, the seller wants to limit the amount of indemnification they have to provide for the buyer side. It might be limited to access to the property and indemnifying for any damage or injuries that occur on the property while the buyer's doing their due diligence. That's what the sellers are going to want to see. They may also be looking for an indemnification for any obligations if there's a lease of the property, obligations to the tenant after the closing. So that's often something that you'll find. And from a buyer's perspective, more important than the indemnification, perhaps, is who's giving that indemnification, what entity is standing behind that. If you have a seller that is a single purpose entity and the only asset it owns is the real estate, and then they're selling that asset, okay, that's great, you have an indemnity, but that entity has no assets to back that up. So
that's so interesting.
Yeah.
Just stop you there for 1 second because I want to dive into that. So, if that's the case and you're a buyer, how do you feel comfortable or what's the workaround?
Right. So this is usually a very fluid process when negotiating the contract, or even after the contract's signed. We have to revisit those indemnity obligations because there's an issue discovered during due diligence that perhaps a buyer is not willing to take on the full risk. For example, an environmental situation, or tying up some loose ends with respect to permitting obligations. That can be dealt with an escrow that is
Right.
held post closing, and really identifying exactly what needs to be done, hiring your own independent consultants as a buyer to understand the scope. So if it's a permit requirement, what does your civil engineer say about that? If you don't have a civil engineer, you need to get one. And
Right.
as the attorney, my role is to help clients navigate those issues, make sure they have the right professionals on board so that they have a full understanding, not just what the seller's consultant says this is going to cost, but has an independent evaluation been done to understand what you need to demand for an escrow.
So, if the entity giving the indemnification is stronger, maybe it's surviving closing, it's not an SPE, do you feel that typically escrows aren't as crucial, or maybe they're less, or are those two totally separate buckets?
I would say that definitely changes the negotiation.
Right.
And oftentimes when you see, for example, a national company that's an operating entity that holds the real estate assets in its own name, they're not going to be willing to give an indemnity because they have the financial wherewithal to back up. I'm sorry, they're not going to be willing to give an escrow or any kind of guarantee because they have the financial wherewithal to back up their contractual obligations. So the leverage of the parties really is dependent upon who exactly is the party to the contract.
And then if you do have to go the escrow way, how do you set that? You said it's the engineers, you have third party advice. Like, how do you decide the dollar amount and the duration? And where do you see that causing friction between the two parties?
Sure. You really need to understand in that scenario who the responsible party for whatever the obligation is. So we could have a situation where it's a tenant that's actually responsible. But what happens if the tenant doesn't do what they're supposed to do? And having guidelines could also be a tri-party agreement or an amendment to a lease involved to make sure that there's a time frame for the work to be done, and an obligation to release escrow if it's not done, or to allow the buyer to take on the obligation and use the escrow if the seller's not proceeding or if the tenant's not proceeding.
Aside from environmental issues that come up during due diligence, when do you see indemnification and escrows coming into play?
Sure. So, if a municipality has obligations for a certificate of occupancy as part of the transaction, and if there are upgrades or repairs required to be made, you're now on a timeline of your local inspector, who may not even be a full-time employee. So that might not happen in time for closing. So there may be post-closing obligations that have to occur to make repairs to the property. And in order to do that, there's also not just what the escrow amount is, but who's doing the work, because then you have to deal with access rights. And if the seller's doing the work, how is that operationally going to work for you as the buyer? So in that instance, the buyer may want to take that on. Depending on the issue, they may be comfortable with getting a credit at closing or a reduction in the purchase price if it's, something that's tangible and you can wrap your head around it.
How often are these provisions changed during due diligence? Or
Often.
often?
Always.
Every day.
No.
No,
I
no.
mean, every deal is different, but it is not uncommon for issues to come up during due diligence that have to get negotiated. And actually, that's one of the things that is important when you're negotiating the contract. You want to make sure that you're not ironing out all the what ifs in your contract when during due diligence, a buyer is going to go through and do inspections. And so in my opinion, it's unreasonable for a buyer to require or demand a remediation obligation or repair obligations from a seller when we don't know what the scope is. So I think it's reasonable to for practitioners to understand that this is going to come up and you're going to deal with it when you know exactly what the issues are.
Right. But there still needs to be some language on the front end, right?
Sure.
So it's
Yeah.
not that you can't address indemnification.
That's where the reps and warranties come in, right? So going back to the reps and warranties, a buyer is going to, at a minimum, require the seller to disclose what they have knowledge of. Right. So the buyer wants to know, what does the seller know? And that's really, I would say, a reasonable solution in most circumstances. Looking for information related to past owners or prior uses, that becomes more challenging because the seller may not have all that information. So a careful review of the representations and warranties and balancing that with the notion that you're going to have a due diligence period to confirm certain issues is important.
Right. Now, what if this is not a stabilized investment sale and it's a development? I mean, there's so many more layers of complexity here. So how would you recommend buyers and sellers approach contracts that are contingent on entitlements or approval?
Sure. So from a buyer's perspective, let's start there. If you're a buyer of real estate and you want to develop a property, you really need to build in upfront flexibility and time to get the due diligence done in terms of understanding what exactly is going to be involved, but then also your entitlements. If you need land use approvals, and if you need land use approvals in New Jersey, you're going to want to build in enough time to not only get your municipal approvals and also deal with any potential issues that could come up there, as well as your outside agency approvals. So you could have Department of Transportation, New Jersey Department of Environmental Protection, stormwater management regulations have to be met. Floodplains have to be evaluated. All of that takes time. And the state agencies aren't necessarily as quick to respond. So that has to be built into the contract timelines in the diligence.
It's a very nice way to say that. They're not necessarily that efficient to respond. Now, from the seller perspective, right, it's a very different story because you don't want to be tied up with a buyer that may or may not be moving forward for endless amounts of time. So if you're on the other side, how do you manage those timeframes?
Sure. So if you're on the seller side, you really want to understand what is the buyer proposing to do and have it identified in the contract so that the obligations of the buyer are understood in terms of this is their project and this is what they're going forward with. So just for example, let's say it's an apartment complex. How many units are they going to go in for? And are any of those going to be affordable housing? That has a big impact on your ability to get the site approved.
Right.
What's the size of the proposed building? I can understand if someone's wondering, well, why does the seller care what the buyer builds? Well, if the seller wants to go in and take farmland and completely cover it with impervious surface, that's probably not going to be realistic. And so you don't want to go down this path of entering into a contract with a proposal for a project that's not going to get approved.
Because then you're just wasting time.
Exactly.
Right? Time is typically money because you have holding costs, et cetera.
Exactly.
So you, as a seller, need to be more involved with the buyer's plans and their time frame.
Exactly. And the buyer may not know what that concept plan looks like at that point. They may know conceptually they're going to do an apartment building, and they may know they have an idea of the units that they're going to do, but that's going to be a fluid project. And so you have to balance what level of approval rights does the seller have? Probably minimal, but you also want communication and transparency in the process and an obligation of the buyer to proceed with diligence in getting their approvals and not just sitting on it.
Do you normally break these up into different time periods? I would think that would be a good way to, I guess, really mitigate risk on both sides. Right. So it's not one blanket approval period.
It's very difficult to identify exact timelines. It's very project dependent, right? So a large industrial project that has a lot of engineering involved could take a lot longer for the design plan to move forward. And in some cases, the first step in the process is meetings with the municipality to determine whether it's going to be a feasible project or not and whether you have the municipal support to do it. So there's also, we talked about wetlands and floodplains before. You don't always know exactly where that's going to layout and how that's going to impact your project. So you have to balance flexibility, but also transparency. So in terms of specific timeframes, you can build in some timeframes for when the application needs to be submitted. I would just expect that there's going to be another conversation to amend that later. So, if you want to make sure that there's milestones being met, what I would say is trust your, not trust, but have the right buyer, know that what's their experience level, what projects have they done in the past. That has a huge impact on what their ability is to get that project done and their experience in what their proposal is.
And that makes such a difference in especially development, right? It's not just the business terms and the price, but can they actually get this done even if they are taking all of these steps? It's so complicated. So understanding their track record is crucial. And that probably impacts how you negotiate the contract, right? If you have a buyer with less development experience and you're representing the seller, you're going to be a little tighter. Right?
Yes, you're most likely going to want to have a little bit more detail in the process, but don't get too comfortable. Even if it is an experienced purchaser, I oftentimes receive contracts when I'm representing a seller that are lacking in the basics in terms of what the seller needs to see with the buyer's proposal. So making sure really the proposed project is identified. What are they trying to build? When are they trying to build it? And understanding what's the temperature in that municipality for that type of project. And what is the zoning?
Zoning, political climate, the town, what's already there, right? All of that is not, often factored in when you're thinking about the business terms, but huge piece, especially in the Northeast where it's not so easy to get stuff approved. Let's switch gears for a minute and talk about surveys and title insurance. So these are two things that should be run on every deal, but we'll often have clients say, it's a Burger King. It's always been a Burger King. Why am I running a new survey, or why do I need title insurance? Especially if they're not financing and it's not required. Why are survey and title insurance important?
Sure. So survey and title insurance are quite possibly the winner for the least glamorous part of real estate. So
I don't know if you ask a title agent or surveyor, they're going to say,
"It's me. I
pretty glamorous.
Am a title insurance nerd and get excited about things like easements." But a lot of my clients tend to just put their trust in me that, I'm going to take a look at all of the exceptions and make sure that there are no issues with their proposed project or their acquisition. What's important, though, is a lot of times a buyer may want to just rely on the seller's survey.
Previous,
Or they think they have a survey and that's sufficient. Well, you have to actually look at the survey and decide, what's on the survey, because what isn't understood always is that there's an exception in your title insurance policy that says there is no insurance coverage for any issue or item or encumbrance that is shown on an accurate survey, right? And that can get removed if you do supply an existing survey with what's called an affidavit of no change, where the seller says, I promise there haven't been any changes to the survey, or you get a new survey. But the endorsement itself oftentimes will identify particular issues shown on that survey that are exceptions. So if there is a fence that encroaches on the property, or the building even that encroaches on the property, then that might not be covered in your title insurance policy. So title and survey go hand in hand, and it's very important to make sure that you have identified any exceptions from your title coverage as it relates to your survey. And then your survey identifies all of those exceptions that are on your title commitment for easements or restrictive covenants, that they're actually plotted on your survey and you understand where they are located. The reason for that is you want to make sure that there are no buildings within an area that is an easement that has a restriction on any improvements within the easement area. That could be
not
incredibly
easy
problematic.
to fix. Yes, I was going to say that's not easy
No,
to
that could be a problem.
fix later.
Right,
Yeah.
exactly.
Now, are these just Alta surveys, or do boundary surveys give you information, or is Alta really like the standard
Alta
that
is
you
the
would need?
standard
Yeah.
that you really want to have, because
Right.
that's going to ensure that it meets all of the requirements for your title policy. There have been times where, a boundary survey may be sufficient if there's not really any title exceptions that need to be plotted, or there could be a situation if it's a residential property. But for a commercial property, the recommendation is to have an Alta survey.
And going back to title for just a minute before we move on, aside from easements or liens on the property, what do you see coming up as, I guess, areas of conflict on title searches?
So one item that comes up quite often in New Jersey is tax sale certificates and tax sale foreclosures. So there's a rule in New Jersey that requires a tax sale certificate if there is already a foreclosure filed and of record. You can't just pay it off.
Okay.
You have to get permission of the tax certificate holder.
Interesting.
If you close on your transaction without getting a consent order, and you have to actually intervene in the case and get the court to approve with the consent of the certificate holder of the transaction, then you don't actually own the property.
Wow.
So that whether you have title insurance or not, that's a problem. And if you did close and your title company did close, they probably didn't catch it. So you might have a title claim. But
wow, interesting. So foreclosure, easements, liens.
Yep. So liens in particular, adverse possession is something that comes up quite often in a post-closing issue, particularly in urban areas where there's less space. We handle title claims work, and many times we have claims made based on an adverse possession claim, and that requires open, hostile, notorious use of land that there is no easement for. But an example would be somebody's just using your land as their driveway, and they've used it for 21 years in Pennsylvania or 30 years in New Jersey. And that's the way it's always been. If you don't get your survey and title insurance, maybe you don't realize it, or it didn't show up on the survey, then that could potentially be problematic after closing when you realize that the neighbor has been
has some sort of claim to it
exactly.
moving forward.
Yep.
Fascinating. I mean, and all of these are real dollars and cents at the bottom line. Like, this is the value of your property. And when we hear clients say, "Oh, I have a friend who's an attorney, or we're just going to review it ourselves," it's like there's so much to this in the contract and the title review that can be a long-term issue for the bottom line.
Exactly. So while it's a legal risk and it's a legal issue up front, it eventually could become a business issue, because you will need to resolve that, or you may not be able to sell your property for as much as you thought you could years down the road because of an issue that wasn't dealt with when you purchased it.
Any final words of advice in negotiating contracts or even LOIs that you wish people kept in mind and they don't?
Sure. So with respect to letters of intent, unless there's some unique issue related to this specific property, my recommendation would be to not negotiate the legal terms of the contract in your letter of intent, and let that wait until you get to the contract stage. The more detail there is, unfortunately, in a letter of intent, while I love detail, the harder it is for your attorney to negotiate back from that. So really just focusing on the business terms and making sure that the letter of intent is not binding, and that the parties agree that this is intended to just be an understanding of the business terms in order to get to the agreement.
Good. I sincerely back that up, because that is a sticking point, right? Especially if clients are offering on multiple properties as part of an exchange. Like, as the LOIs get too complicated, it's just not an efficient process.
Exactly.
So having it be a simple outline of the business terms and then letting you do your job to protect them on the contract side is a much smoother way to go.
Exactly.
Yeah.
Exactly.
Well, I know this is just the tip of the iceberg, but I very much appreciate you sharing contract provisions that kind of hold up deals and what that looks like from both the buyer and the seller side. I think it was great advice, and so happy we could join together for this conversation.
Thanks, Carly.
To everyone listening, that was this episode of Commercial Real Estate Now, live from Key West. We're so happy you tuned in and look forward to seeing you again very soon. Have a great day, everyone.